Good evening, ma.
How's your day been, sir?
Fine, thank you.
You and Adeleke, you are welcome to this call.
Yeah, good evening.
Good evening, ma.
How are you, madam?
I'm fine, thank you, ma. How's your
Wow,
day
you're
been?
looking fine. You're looking great.
Thank you, ma. Lola, you're welcome to this call. Lola, you're welcome to this call.
Yes, ma'am. Good evening.
Good evening. Good evening, everyone. I want to appreciate you for joining me on this program, interactive session with Grace Ojo. I want to wish every one of us a happy new month. It's a new month of October, and I wish you all the best.
True. Happy new month.
Thank you, ma. Yes, we started this program last month, the month of September, and when we started with the fundamental principles of insurance. And we have discussed so far 5 out of 6. We have learned what insurable interest is. We have understood what the utmost good faith is, proximate cost, indemnity, and last week we talked about the principle of contribution. So today we'll be rounding up on the fundamental principle of insurance. We'll be discussing the last one, but before I introduce the last principle to us, I have a question for us. I would like you to unmute your mic and answer the question. Now, let me ask the question. The question is, supposing you are driving and somebody hits you, you had an accident, somebody hits you from the back, and the person was able to accept the liability that, oh, you know what's happened, what usually happens in Nigerian setting, when you hit yourself, people will come out and they start fighting and all that. Now, supposing the person actually accepts that, oh, so sorry that he hit you and all that, would you rather want the person that to fix your car, or you would like to call on your insurance to fix your car for you? That's number one question. Now, another question is, if that man agrees to fix your car, will you still call upon your insurer to still fix? Will you still make claims from your insurer? I hope you can understand my question. Please unmute your mic and answer the question. Thank you. I'm waiting. It's an interactive session. I need response to the question, please. Conley Felix, you are welcome.
So, if I get the question clearly, you said if the person decides to repair the car, will we still reach out to the insurance? Was that the question?
Yes, that's my question.
Okay. Well, I guess it depends on where you are.
Okay.
But yeah, if the person decides to repair the car, then I don't know. Would it be necessary to still reach out to the insurance company? I don't know. I probably wouldn't. And if and the question was the other way around as well, right? So if the person refuses, will you reach out, right?
No, if the person has fixed your car, do you still need to reach out to the insurance company?
Maybe you do, because you need to maybe inform them that some of the situation and what has happened, maybe just to update them. I don't know, but I don't know if there's going to be a difference if you do.
Thank you, Molola. I appreciate your response. Peter Adebola, you're raising your hand. Kindly unmute and respond to the question.
Okay. Good evening, everyone, and good evening, our teacher. Yeah. Okay, my own answer is this. If the person that hit me from the rear, if the person that agreed to fix my car, there is no need of bothering my insurance company anymore, because the person is at fault, hitting me from the rear. So I will allow him to go and fix the car without bothering my insurance company about what had happened. Although if they come for inspection, I might have just informed them that, look, somebody hit me at the back some times ago and the person fixed the car. But for me, they are not going to, my insurer is not going to be the first point of call if the person had agreed to fix my car. That's my answer.
Okay, thank you very much, Mr. Adebola. I really appreciate you for the response. On that note, I want to introduce today's topic. Today's topic is subrogation, which is the last principle. You know, we've been discussing the fundamental principles of insurance, and today we'll be rounding up on the fundamental principle of insurance, which is subrogation. Now, let me read this for us. This is the right of an insurer to stand in the insured position and pursue his rights of recovery, having fully indemnified the insured. Yes. The two participants that responded to my question, yes, you have an idea of where I'm going to. Once your insurance, the person that hits your car was able to fix your car, you don't need to call on your insurer again. However, this principle of subrogation actually takes off the stress from the insured. It's to the advantage of the insured. The principle of subrogation takes out the stress for you to be pursuing the person who hits your car. Once you have an accident, you are just to inform your insurer. When your insurer indemnify you, then your insurer can now go after the third party that caused the liability, the person that hits you, and subrogate and recover from the subrogation is the right of an insurer. Your insurer would have first indemnify you because that person is at fault. It is that person's liability, but you don't need to stress yourself. You don't need to start dragging with that person. That is why most times when people are fighting on the road, it's because they don't know their rights, or because they don't know, probably, in this part of the world, in Nigeria, some of us don't even believe in insurance. You don't even know what insurance can do for us. If you are adequately insured and you have a loss, your point of view, because the one that is very easy for you is for you to call upon your insurer, and your insurer will, of course, your insurer will investigate. They want to know the proximate cause. We have discussed about proximate cause. They want to know the cause of the law, and in the course of investigation, if they find out that there is a third party liability, like for that, for example, that man that hit you, that is responsible for your loss. So your insurer, it is not the duty of your insurer to go after that man if your insurer has indemnified you. So that is what the principle of subrogation says. That because just like I told us when we were discussing about indemnity, that indemnity, that the policies of indemnity, you are not to make gain from policies of indemnity. You cannot make that person cannot fix your car, and at the same time you go to your insurer, which means you are making gain. And the principle of indemnity says the insured cannot, the insured will be fully indemnified, but can never be more than fully indemnified. That is, you cannot make profit from your loss. So once your insurer settles you, and we are able to establish that somebody is responsible for that loss, your insurer will go after that person. So it is, the principle of subrogation takes some stress from the insured. Instead of you to be chasing after the person, no, you just report the claim. Your insurer will settle you, and your insurer will not take it upon themselves to subrogate after the third party. So that is what the principle of subrogation says. Now, I want to discuss the 3 ways under which subrogation rights may arise. Subrogation rights may arise under statutes, in torts, and under contracts. Now, under statutes are not law. When each time we hear that is when things, those are statutory rules that are talking about law. So under statutes, now, like for example, the Road Traffic Act. Road Traffic Act is an act of parliament. It's a statutory, is a law that is govern people who are riding vehicles. It is expected that before you can put your car on the road, you have to have at least third-party insurance. So when liability occurs, just like the instance I cited, and look from the picture on my slide, when the man hits you, I mean, it is expected that that person that hits you should have at least third party. So it is the third party of that person that hits you that should settle your claim. But in the case where he does not have that third party, that is when the man may want to fix it, or if your insurer now settles you, your insurer will now go after that person. So on that instance, subrogation rights occur. So under statute, subrogation rights can occur under statute. Then in torts, what do we mean by torts? Before we can establish a tort, we call it tortious liability. There must be a duty of care, and there must be a breach of the duty of care, and the person, the claimant, must have suffered damage. Now let's look at the case of negligence. Is it when a tortious liability arises through under negligence, the insurer has the right to subrogate after the negligent third party. Now, for example, from the picture on my slide, look at this man, a welder. Maybe in the course of doing his welding operation, maybe the fire from the machine or something, he showed that maybe a fire incident occurred, and maybe there's a loss. So once it is established that it is through the operation, it is when this man was doing his carrying out his professional duty or his operational work, and maybe a fire occurred from that and there's a loss. So if insurance settles that, let's say for example, maybe a house is close to this place and that house caught fire through the act of this man that is doing his welding operation. If that house caught fire, if the insurer settles that claim, the insurer will go after this man or his company, and the insurer has a subrogation right to pursue this person because it's a negligent third party. Then under nuisance, we have examples of tortious liability: negligence, nuisance, trespass, defamation. When somebody is constituting a nuisance in the neighborhood and people are like, oh, this person is disturbing us, maybe there's a damage, because there must be a damage. Whatever it is, under tortious liability, if the claimant suffered damage, then if your insurance settles you, your insurance rights, obligation rights, go after the third party that causes damage through tortious liability. I hope we can all relate with that. Then the last way, the third way, is through contractual liability. Like the case of Beli and Bello I cited last week, when you put your car with a mechanic and the car was stolen or the car was raised down the fire in mechanic's place. And I said, if your mechanic has insurance, it is the insurance of your mechanic that will be primarily liable to that loss, that they will settle that claim. But if your insurance does not have, if your mechanic does not have the insurance, your own insurer will settle your claim. But your own insurer will go after the mechanic because it's a contractual liability. No, that loss result as a result of you have a contract with your mechanic and the loss has occurred. So it's a contractual liability. So on that note, your insurer, when they settle you, they can go after that mechanic, to subrogate. I hope we can understand what the principle of subrogation is. It's the last principle of the series of the fundamental principles we are discussing. And I said that the principle of subrogation is to ease off the stress. It takes off the stress from the insured. Once you have your loss, you report your claim to your insurer. Your insurer will settle you, but your insurer it will not be you that will not have to be doing the stress of going after, instituting a legal action or whatever it is against the third party. So the subrogation right is to ease off the stress, is to take off the stress of the insured when loss occur as a result of third party liability. I hope you can all relate with this. I want to give room for questions because our time is going. It's just 30 minutes interactive session with Grace Ojo. And just like I said, once I make my presentation, I always want people to respond to ask questions so that we can all clear our doubts. Just like I said, the purpose of this program is to bridge the knowledge gap in the insurance industry and to demystify all the complex, to demystify the fact that people always say that the insurance don't pay claim. No, this program is to enlighten us and to understand why and what happens, what goes on in the insurance industry. Peter Adebola, you are raising up your hand. Can you unmute and ask your question, sir?
Okay, thank you very much for that wonderful presentation. Now, I'm comfortable about what my insurer will do, at least taking the stress away from me by the reason of subrogation that you taught us. But the question is this, that you said if my mechanic actually caused damage to my car or any other third party, that my insurer would like to go after the erring party after fixing my own car or my asset. But the question is this, that how will the insurer get the details of this person that has actually caused the problem? Because right now, my insurer may not actually have relationship with the party that hit my car. So they won't have his detail. And in some cases, some people give details that are not even correct. They give information that are not correct. So how would the insurer now be able to trace this person? And in case the insurer could not actually trace the person to make a claim against the party, so what would be the recourse of the insurer to me?
Okay, thank you, sir, for that question. Yes, when loss occur, insurer will always ask questions. You fill claim form, and so those are the questions. Some of the such questions would have been asked. Insurer will be able to through the questions would have provided. They would have known that okay, the accident was caused by this person, and you'll be asked to provide the detail of the third party. If it has been established that it's a third party liability, and so you will get the detail. You'll get the detail. So it is from the information you provide that the insurer will act on. Have I been able to answer your question, sir?
Yes, you are. Thank you very much.
Lola, you are raising hands. Please unmute your mic and ask your question.
Yes, my question is thank you very much for the presentation. My question is actually kind of related to what Mr. I can't remember his name. I was asking. Yeah, so I wanted to ask as well. So say you actually your mechanic actually has an insurer. Let's assume, I know this will be very rare, I think, in Nigeria, but let's assume that he actually does have an insurer as well. My question is, do you have to have a written contract with your mechanic for your insurer to be able to actually claim anything, or can they just go on the basis that this is my mechanic and I will always take my car to this person?
Okay.
Yeah.
Okay. Just like I said, when we're talking about, okay, I refer to the mechanic because I talked about it last week. What happened is that mechanic is your bailey, as in is the one in custodian of your car as at the time the loss occur. The loss occur in your mechanic workshop. What I said that last week is that if your mechanic has insurance, it's your mechanic will report the claim because it happened in his workshop. So because he also has insurable interest in that car that was put in his custody. So it is his own insurer that will indemnify him. And once they indemnify him, maybe they replace the car for him. The mechanic will just return the car to the owner. I hope you understand what I'm saying.
Yeah, so, but what if the guy doesn't agree, like that it happened in his custody, kind of something like that?
Like the scenario I gave last week is that you have put your car in his workshop to fix for you. Maybe the car stayed there overnight and maybe fire occur in his workshop. Do you get it? The loss occur maybe as a result of fire or the car was stolen. It happened in his custody. So it is his own insurer that is liable. But if he does not have insurer, it means it will bear the risk. So even if your own insurer settles you, your own insurer will go after him.
Yeah.
Because your own insurer will have subrogation rights on him, against him. Do you understand?
Okay. So it doesn't have to be like any written contract because your car was with this person at the time.
Yes.
Yeah.
Because as a custodian of your car, he too ought to have insured it. I talked about bailey and bailor. Bailor is the owner of the risk. But when the risk is in the custody of another person, that person is the bailey. So that bailey also has insurable interest. One of the principles is insurable interest, which we have discussed. You can refer to my YouTube and watch it. So we've talked about insurable interest. So because bailey has insurable interest, he can insure whatever is in his custody. Have I been able to answer your question?
Thank you, ma'am. Okay, yes.
Do we have, you under Adeleke, you have question? Okay.
Yes. Hello, good evening, everyone.
Good evening, ma'am.
Can you hear me? Yes, the issue I have here is I'm wondering how many of Nigerian mechanics that will have insurance, that are insured. That's what I'm thinking now. If such a thing occurs and okay, let's see, because I'm just looking at it that Nigerian mechanics, all these mechanics, do they even understand what insurance is all about, let alone having one? So in a scenario whereby such a thing happens and the mechanic does not even know anything called insurance, what happens? What's the way out?
Okay, thank you. When you go to all these standardized mechanics, like say for example, Elisade, the mechanic, the workshop aspect of Elisade, those big names, they have insurance. But the roadside phone that do not have, that is why we said he is liable, because it is expected of him. Just like I said, that subrogation rights, you can have it under statute, under contract, and in torts. So by virtue of the contract he has with you, he should have secured his own interest. Anybody that does not do insurance, you are saying you are your insurance of yourself. You are saying when loss occur, you are able to carry your loss. Even as individuals, as corporate organizations, if you do not do insurance, all you are saying is that you are able to carry your loss by yourself. That is the simple definition of if you are not covered. That is why having a cover is very, very important. If you say you will not have cover, you are just saying you are ready to carry your loss whenever it occurs. So if the mechanic, the roadside, if he does not have if he does not have insurance, Yes, your insurer, your own insurer will indemnify you. They will still go after him. They probably, they will settle it. Maybe we beg them or not, but at least they will still try and they will go after him, and whatever he can part with, he will part with it. I hope I've been able to answer your question, ma'am.
Yes, you have. Thank you, madam. Thank you.
ma'am. Do we have another person? Any other question? Okay, I can't see anyone, but if you have any question, you can still unmute and talk about it.
Yes, I raised my hand.
Oh, I thought I've got, okay. Talk, sir. Go ahead, sir.
Okay, my question is related to the question that Mrs. Adeleke actually asked.
Okay.
And the question is this: most of these mechanics in our car.
I'm sorry, my internet was disrupted. Please ask your question again.
Okay, the question is this: that most of these mechanics that we have around us, that most of them don't even have insurance. And I have a comprehensive insurance scheme on my car. And anything happen at my mechanic workshop, and I have to call on my insurer that, look, it had happened. Oh. Are you saying that my insurer would not indemnify me if the other guy does not even have insurance or does not have anything? Am I not entitled to lay claim to my insurer and leave the other guy for them to repair my car?
Thank you, sir. I've answered the question. I said your insurance. When Mr. Adeleke was saying that, I've answered the question. I said your insurer will go ahead and indemnify you, but they will go after the mechanic. So even if the mechanic does not have insurance, if they go after him, even if he cannot afford it, he might beg. You know how it happens now. He might beg, he might, but at least they will go after him. And if they say that he cannot do anything, at least they will take something from me. And if they cannot take anything, it has gone. But that is the right thing is that if your mechanic does not have insurance, your own insurer will indemnify you and go after your mechanic because it's a third party liability. But that doesn't mean you will not be settled. You will be settled. That I've established. Even last week we established that you will be indemnified. Have I been able to answer you, sir?
Yes, you answer.
Mrs. Adeleke, are you still raising up your hand? Mrs. Adeleke.
Okay. No, madam. Sorry,
okay,
I didn't drop my hand. I forgot to
Thank
drop
you
my
so
hand,
much.
Yeah.
I really appreciate everyone that has joined me on this call. This program
Don't know
is
if I can. Is
you
it
have
too late
another
to ask you?
question? Is anybody?
Just one more. I just the part where you talked about negligence.
Okay.
I wanted to ask if how this can really be determined. Like, is there going to be like an investigation raised by the insurance company, or how do they like determine that something happened through negligence?
Okay, just like from the first question I asked before I introduced the topic, we were able to establish that, okay, the person hits you. That one was established. Yes, when anytime loss occurs, insurer will do their investigator. They will do their investigation. Insurer will do their investigation, and the result of the investigation will determine what happens. If it is a case of third party liability or negligence, when it is established, fine, they will settle you and they will go out after the third party. But if there's if it is not established, the insurer will still settle you. It's a principle we are discussing. We say it's a subrogation right of the insurer. So if there is no case of negligence, if loss has occurred and they were not able to establish third party liability, insurer will go ahead and settle your claim. Just when we are talking about proximate cause, that with the insurer will want to know what led to the loss, what is the peril, what was the cause of the loss. So when insurer is clear with all his investigation, insurer proceeds to settle claim. 3 participants are raising hands. We have to round up now. Oluwatoyin Dayo. Okay, I'm not. Okay, you can unmute and talk and say your question, please, because our time is rounding up, fast rounding up. Can I hear your question, please? Toyin Dayo, I saw you were raising hands. Omotola, please unmute and talk.
Okay, ma. Yes, I know I didn't join from the beginning, but I know that from last week we were talking about the contribution and we touched on subrogation a bit. Yeah. I just, my question last week also was that, for example, the mechanic, they can always claim that, or they don't have insurance and they don't have money, but yet the insurer has established that there was negligence and they're liable. Yeah. Isn't there a legal avenue to force them to pay what they owe, and rather than just saying, oh, you leave them alone because they say they don't have money? They can, anyone can always claim they don't have money. So what's the how do we bring the law into it, into enforcing them to pay when they're liable to the insurer?
Yes, I think I've answered that question. I said once your insurance says you, they will go after the mechanic. So even when he's saying he doesn't have money, the worst scenario that can happen is for the insurer to put a human face to it and say, okay, whatever you have, bring it. It must start with something because it's his liability. Okay. Do you understand?
Yes, ma'am. Thank you.
Thank you very much. On this note, I think we have to bring the meeting to a close because I'm getting signal that my time is up. Thank you everyone that has joined me on this call. It's 30 minutes interactive session with Grace Ojo. Let's meet next week again. It's another time, 5:30, between 5:30 and 6. I really appreciate it. You can reach out to me through my email, info@graceojoblog.org or 080-269-40605. If you have anything, if you have a need for insurance, you can reach out to me. That is why this program is out. Just like I told you, I run a insurance consultancy firm. So if you have any need for insurance, please call on me. Your insurance needs will be satisfactorily met. Thank you everyone for joining me on this call. I really appreciate everyone. Do have a great evening.
Thank you.
Thank you
Have
so
a good
much.
evening.
Thank you. I really appreciate you.
Have a great evening too. Thank you, madam.
Thank you, ma.
Thank you.
Thank you, ma.
Thank you. Bye-bye.
Thank you. Have a wonderful evening.
Okay, thank you. Bye.
Thank you so much. I really appreciate you. Yeah. Thanks for joining. Who else is raising now? Okay, it's you. You've now put down your hand. The time is up. Thank you, everyone. Okay. Next week is another time.